Now I am going to dictate a latest judgment of Kolkata High Court for Malda District Court exam at the rate of 120 words per minute. Let's start. In the order dated 26 June 2018, the learned single judge held that the petitioner was in a position to lead secondary evidence in support of his claim before the adjudicating authorities, and as such the claim for compensation need not be assessed at that stage. Subsequently, however, the petitioner was not permitted to use the documents available as secondary evidence, for which the petitioner again approached the writ court which, by its order dated 11 August 2021, observed that the writ court was not the appropriate forum to decide the issue since disputed questions of fact and law were involved which required evidence to be adduced. Being aggrieved, the petitioner preferred an intra-court appeal against the same. The said appeal bearing apport to 45 of 2022 was disposed of wide order dated 17 May 2023 affirming the order of the learned single judge. In the said judgment, the division bench observed that as rightly held by the learned single bench, the issue raised by the appellant involves disputed questions of fact which obviously cannot be adjudicated in the writ petition. It was further observed that, however, it will be well open to the appellant to pursue the other remedies available under law, if so advised, before the appropriate forum. Thereafter, when the petitioner approached the respondent authorities with his claim for compensation damages, by the impugned order dated 9 October 2023, the Additional Chief Secretary Government of West Bengal, by in one sentence reason, turned down the said claim. The only reason given was that the fact reveals that the discrepancy cropped up due to inter-se business dispute between the petitioner and a private party, and the government of West Bengal does not have any kind of connection with that bilateral business dispute in between two private parties. It is argued that the government did not specifically controvert or deny the claim of compensation of the petitioner, but turned down the petitioner's claim on grounds extraneous to the issue. Learned counsel for the respondent authority submits that the issue in question was closed by the order of the division bench when the division bench clearly affirmed the findings of the learned single judge holding that the matter concerned civil disputes and granted liberty to the petitioner to approach the appropriate forum as advised. It is argued that the government itself is not the appropriate forum and there is also no scope of further approaching the writ court, which approach was previously turned down up to the division bench. In view of the nature of the allegations made by the petitioner in the present writ petition, it transpires that the petitioner's claim lies in damages compensation against the respondent authorities. Although learned counsel for the petitioner vociferously argues that since the respondents have not categorically denied that the claim for compensation is payable to the petitioner, there is no denial as such of the said compensation, such argument cannot be accepted for the simple reason that the respondent authorities are not the adjudicatory authority to decide claims made against the respondents themselves. Whatever might have been the stand of the respondent authorities, tenable in law or otherwise, by the impugned decision dated 9 October 2023, the respondent authorities have rejected the claim of the petitioner. Relegating the petitioner back to the same respondent authorities would not ensure to the benefit of the petitioner. Obviously, if the claim of the petitioner for compensation damage was undisputed by the respondent would have said so and or admitted the same in their order and taken steps for disbursing the said amount to the petitioners. Nothing in the impugned decision dated 9th October 2023 can be construed as an admission of the claim of the petitioner regarding damages compensation. Hence, relegating the petitioner back to the respondent authorities in respect of a claim made against the very same authorities would be a futile exercise and would kill further time for the petitioner, who has lost sufficient time in moving successive writ petitions on a cause which revolves around a pure civil dispute. As such, although the petitioner prays for a re-relegation to the respondent authorities themselves, the same would not suffice to give proper remedy to the petitioner. The only remedy before the petitioner in respect of his claim for compensation damages is before the competent civil court, which has been held time and again, previously by the writ court, and then affirmed by the concerned division bench in appeal against the said order of the single judge. Thus, instead of wasting further time for the petitioner by relegating the petitioner back to the very respondents against whom the petitioner has made the claim, liberty is granted to the petitioner to go to the competent civil court and get his dispute resolved once for all. In view of the above observations, WPO 1789 of 2023 is disposed of by granting liberty to the petitioner to approach the competent civil court with his claim of compensation damages against the respondent authorities. If so approached, the competent civil court will take a lenient view with regard to limitation in view of the long pendency of the present writ petition and the previous writ petitions, and appeals preferred against the orders passed in such writ petitions. It is made clear that the merits of the claim of the petitioner and the defense thereto by the respondents have not been gone into by this court, and it will be open to the competent civil court to decide all such issues in accordance with law. No order as to costs. Urgent certified website copy of this order, if applied for, be made available to the parties subject to compliance with the requisite formalities. Stop. Thank you.